This is Bloomberg Law with June Grasso from Bloomberg Radio.
A 90-year-old legal precedent setting up independent agencies isn't dead yet. But after the Supreme Court's emergency order last week allowing President Trump to fire members of two independent agencies, the effect may be the same. The court's 1935 ruling in Humphrey's Executor said that Congress in some instances can set up agencies that are independent from the executive branch and whose members can only be fired for cause. But in recent years, the Supreme Court has significantly cut back on Humphrey's. And last Thursday, over the dissents of three liberal justices, the court allowed Trump to fire National Labor Relations Board member Gwynne Wilcox and Merit Systems Protection Board member Kathy Harris without cause as their legal challenges play out. My guest is Lauren McFerran, Senior Fellow at the Century Foundation and former chairman of the NLRB in the Biden administration. Tell us about the Supreme Court's emergency order last week.
So what the Supreme Court did was stay an order of the district court, which had ordered the reinstatement of Gwynne Wilcox and Kathy Harris. And the removal of Gwynne and Kathy from office was clearly contrary to statute. You know, the president is prohibited by both the National Labor Relations Act and the law governing the Merit Systems Protection Board from removing people from office except for cause, and no qualifying cause was given to either of these officials. So it was, the action was clearly contrary to law. And so the president kind of took the law into his own hands here and basically said, I don't care what Congress wanted, and I don't have to follow Supreme Court precedent, and he removed them from office anyway. The Supreme Court then stepped in and on what's called the shadow docket, which is supposed to be for emergency relief and emergency orders, indicated that the president was right to do that it is okay for him to ignore Congress and to ignore Supreme Court precedent, and kind of went to extraordinary lengths to keep that result in place because they basically think the president took a good gamble about their plans to revisit precedent. So it was very unusual from a court process perspective. The so-called shadow docket is supposed to be used for, like I said, emergencies. It's typically also used to preserve the doctrinal status quo, not to overrule it. You're certainly not supposed to use the shadow docket to effectively change precedent without the benefit of full briefing and careful consideration, which is what the dissent pointed out. So it was a procedurally very odd thing to do, but it certainly sent a very strong signal about where the Supreme Court is headed in terms of whether it plans to overrule Humphrey's Executor, which is the decision that had originally upheld Congress's ability to create positions like this that can only be removed from office by the president for cause.
So according to the dissenting justices, the effect of this is essentially to overturn Humphrey's Executor.
I think that will be the practical read that a lot of people take away from it. Now, the majority did ultimately hedge on that question. The majority said that they're not ultimately deciding whether these two agencies fall within the recognized exceptions of Humphrey's Executor. That does suggest that there still will be some recognized exception, but they signaled pretty clearly that they didn't think either the National Labor Relations Board or the Merit Systems Protection Board would fall within that exception.
Tell us about Humphrey's Executor. It's sort of been on the way out, or people have been calling for its demise for a long time.
I mean, Humphrey's Executor, there's no question that it is still good law. The case that everyone cites for the proposition that Humphrey's Executor is on the way out the door is a case called Seal of Law. And Seal of Law was very careful to say that Humphrey's still is good law and that they were not revisiting Humphrey's. But what they did was that they certainly said they were not expanding Humphrey's Executor to encompass independent agencies that aren't like the Federal Trade Commission that was the original subject of Humphrey's itself. So they were unwilling to expand the reach of Humphrey's Executor, this exception that allows Congress to create entities whose leaders can't be removed except for cause. They weren't going to expand that exception to a single-headed agency like the Consumer Financial Protection Bureau. But it is very clear that Humphrey's, at this point in time, or at least until this order issued, that Humphreys itself, with the exception it creates for quasi-judicial and quasi-legislative agencies that are structured like a multi-member body, like the National Labor Relations Board and the Merit Systems Protection Board, still exists, and that exception is still valid.
The Supreme Court in recent years has cut back on Humphreys. I mean, it's still standing, but is it in sort of tatters?
I think it's safe to say that the court has constrained its reach and has at times, one or two justices in a separate opinion or in dicta in a majority opinion have called into question its continuing viability. Basically, this notion that there can be an entity, even if it is structured like a multi-member body, even if it is a body of experts that's supposed to make expert decisions, that there could be an entity like this that would not be sufficiently executive in the nature of the powers that it is exercising, such that its leaders should not be removable by the president. I mean, that's the core issue here for proponents of the unitary executive theory on the court, is that any entity that is exercising any level of executive power should be removable from office by the president. And the court has certainly sent signals in recent years that it thinks the scope of the universe of agencies that might actually not exercise any executive power is minimal or non-existent.
The justices took pains to point out that this doesn't affect the Fed. The Fed is different.
Yes, that was a really strange little red flag in this decision. It kind of comes out of nowhere in the decision. They might as well have basically said, oh, by the way, President Trump, please don't take this order as a green light that you can fire the chair of the Fed. And they carved out the Fed in like two sentences when it wasn't at issue in the case. And they carved out the Fed by making what is basically a factual observation about the Fed, which is that it is uniquely structured and it has a distinct historical tradition. That is factually true of many independent agencies right now. My own agency that I used to work for, the National Labor Relations Board, that is certainly true. It is uniquely structured and it has a distinct historical tradition. But that doesn't speak to the reasons why the Fed is independent, which are fundamentally similar to the reasons that other independent agencies are independent. The reason that Congress chose to create independent agencies is because it wanted to have entities, even entities within the executive branch, that made decisions based on expertise and that made decisions and were capable of making decisions that might be in the short run politically unpopular, but in the long run in the best interest of the country. And it's very easy to see, of course, how that plays out in the context of the Fed, and particularly when the Fed is wearing its monetary policy hat. It's very easy to see why it's going to have to make decisions that are short-term politically unpopular, but long-term beneficial to the country. But the Fed is not unique in that regard. And one agency that leaps to my mind, for example, is the Consumer Product Safety Commission. Sometimes it is very politically unpopular to find a product to be unsafe or to pull a product off the market, but it might well be in the long-term public interest. So there's not something that makes the Fed distinguishable in a principled manner from other independent agencies when it comes to the reason for its independence.
Let's say the Supreme Court does get rid of Humphrey's executor. What might the repercussions be?
Well, it would depend on how the Supreme Court did it. There's lots of people who predict about these things, and there's a group of predictors who say that they will basically get rid of Humphrey's executor, but carve out the Fed, or at least the Fed in its monetary policy role. I think there's an argument to be made that they could also kind of split the baby in different ways. I think one of the most difficult challenges that we will have in a post-Humphrey's executor world, if Humphrey's executor is swept off the book, is what to do with agencies that are primarily adjudicative, that do business as courts, basically. And it's very hard to imagine how an agency that's supposed to function as a court will function when its adjudicators can be fired for the outcome of individual decisions. So I think there's potentially a chance that the court could also look at the various functions that agencies are performing and say, these are executive and these are not executive. And this order, being a preliminary order, doesn't delve into that at all. But you could have a court that says, well, if an agency is making rules, it is by nature executive because rulemaking is an executive function, but leave open the question, for example, of whether if an agency was truly just a court system, like the tax courts or something like that, whether that potentially could be treated differently. So I think it's a question of whether the court will just wipe Humphrey's executor off the books altogether with some possible carve out for the Fed and monetary policy, or if it will kind of pick and choose which agency functions it deems to be so executive in nature that the president must be able to control them.
And as far as your old agency, the NLRB, what effect would it have if the president is able to fire board members without cause?
I think it's really hard to overstate how different that would be from the way that the agency operates now. The NLRB and many other adjudicative agencies, like I said, the NLRB does business primarily by deciding cases, like a court. And we as judges never had to worry about whether our decisions were going to be politically popular or politically unpopular, or whether we were deciding a case in favor of somebody that the president was friendly with or someone that the president was not friendly with. I think you can see this playing out totally differently in a world where board members, i.e. the judges, could be fired for the outcome of a particular case. So it will go from being an adjudicator that jealously guards the integrity of its adjudicative process and tries to treat like cases similarly whenever possible, to being a fundamentally different and political entity where judges are making decisions at the peril of their job based on their predictions about whether they'll face backlash for them or not.
Thanks for joining me, Lauren. That's Lauren McFerran, Senior Fellow at the Century Foundation. Coming up, Trump versus Harvard. This is Bloomberg. President Donald Trump has been waging a campaign to pressure elite colleges to make a wide range of policy changes. And Harvard University, the nation's oldest and richest university, has borne the brunt of it.
They have $52 billion as an endowment. They have $52 billion. And this country is paying billions and billions of dollars and then gives student loans and they have to pay back the loans. So Harvard's going to have to change its ways.
The administration has already moved to freeze more than $2.6 billion in federal research money and block Harvard's ability to enroll international students. The latest escalation, the administration is moving to cancel all remaining federal contracts with Harvard, worth an estimated $100 million. And Trump is also threatening to divert $3 billion of grant money away from Harvard and give it to trade schools. My guest is Jodie Ferise, a partner in the higher education practice at Church Church Hittle Antrim. Let's start with the Secretary of Homeland Security, Kristi Noem, revoking Harvard's certification to host international students. And it didn't take long for a judge to issue a temporary restraining order to stop that from going through. What was Harvard's argument against what the Department of Homeland Security had done?
I think what Harvard's position is that the very act of doing that was, quashing their First Amendment free speech rights because of the nature of what they were saying. They were indicating, the administration were indicating that Harvard was, fostering and aiding and abetting this anti-Semitic behavior there on campus. And, and I think Harvard's saying, hey, you're basically holding us hostage, which is, in fact, what that is. It is holding an institution hostage unless they bend to the will of an administration. And, and that's not their right to do. But there was no process to it at all, right? It was a swipe of the pen. It was a very sweeping action taken because what Harvard was being asked to do was to kind of fling open the books for a fishing expedition into the acts and actions and behaviors and academic files of 7,000 international students without any kind of probable cause to do so, right? They were being asked, it was just such an overreach, such an overbroad request. And that is, I think, part of what Harvard was saying. You can't do this. You can't just shut this process down just because we wouldn't bend to the will of an inappropriate request in the first place. with no due process whatsoever.
Due process claims and claims of not following the Administrative Procedures Act seem to be frequent complaints against Trump administration actions.
I think that's probably the most shocking part of what we're seeing here is that these things are happening with a swipe of a pen instead of any kind of due process that is sort of foundational to who we are as a nation, right? So we're going to, with a swipe of the pen, we're going to, take away billions of dollars in research funding, no matter what it was for, right? No matter the importance or the value of it. We're going to threaten your tax-exempt status without any process, without even the notion that you lose tax-exempt status for a very finite number of reasons after a very lengthy process, but that's been threatened. Taking away CVIS registrations with no process whatsoever, doing these things by a swipe of the pen is a really dangerous government overreach. And Harvard is an easy target. It's not something that the American public is likely to rally behind. It's not something that everyone in America harbors great warm feelings. But the actions being taken here are dangerous because with no due process whatsoever, if this can happen to Harvard, and this is what I think is so important for folks to remember, this can happen to 3,900 non-elite, non-selective educational institutions that are doing really important work in communities across the country. I think that's what's important.
So the blocking of the grants was the first thing, I believe, that Harvard took to court. But I don't think those grants have been restored.
Not only have they not been unfrozen, but they've also been told not to apply for new grants. And so I think I used the term earlier. It is my opinion that we are in a hostage situation here, and that amount of funding for really critical research in progress is creating a hostage situation where that amount of pressure. And Harvard is doing everything in their power to backfill that with private funds, but that is not going to last forever, right? That's not a forever solution. That is a temporary solution to an existential problem. But those who are going to be affected by that, that's all of us, right? That is all of us. So to my knowledge, those have not been unfrozen.
The Trump administration is moving to cancel all remaining federal contracts with Harvard worth an estimated $100 million. And in a letter seen by Bloomberg News, Federal Acquisition Service Commissioner Josh Gruenbaum, in directing federal agencies, alleges that Harvard has continued to engage in race discrimination, including in its admissions process and in other areas of student life. And he referred to alleged discrimination at the Harvard Law Review. And a federal task force did recently call out the Harvard Law Review's award of a $65,000 fellowship to a protester who faced criminal charges for assaulting a Jewish student on campus. How does that all fit in?
Well, I think you're asking, though, is there a way of canceling all contracts based on one that may have been inappropriate, right? Mm-hmm. So, again, what these are sweeping overreaches, right? So, I think in the letters that Harvard has responded, they have often said we can do better. We recognize we can do better, but to cancel everything based on one with a swipe of the pen, that is an overreach. And so it was the same way with admissions, and Harvard's response was, we can do better, let us work. But this is a negotiating tactic. This is what we're seeing here is not a direct request to remedy a particular situation that may or may not be inappropriate. What it is a negotiating tactic to try and accomplish the whole slate of requests that were sent. And it's a way of increasing pressure on Harvard to bend to the will of an administration that wants a certain thing, right? And so far, Harvard has been unwilling to do that. So I consider this just one more negotiating tactic, though it may have been an instance of something that may, in and of itself, when you cancel everything based on that, that's too much. You've gone too far.
You mentioned the president wants to revoke the school's tax-exempt status. Tell us about that and what kind of roadblocks it might face.
So there's a well-worn path for revoking tax-exempt status, beginning with an audit, an IRS audit of whether or not the institution has retained its tax-exempt purpose, has done its appropriate documentation, it's done its tax filings, it's not engaged in inappropriate actions, political actions and other things like that. So inappropriate lobbying, something, those kind of things. But what has happened here is that the administration has just threatened to just revoke it as if that is a thing that can be done, because they're indicating that Harvard's no longer serving its tax-exempt purpose. But the Harvard's tax-exempt purpose is education, and it's difficult to make the argument that Harvard is no longer engaging in its tax-exempt purpose, education, when it very clearly is. And so, again, I think these mounting pressures are negotiating tactics. And, were it not for the fact that Harvard is well enough resourced to defend itself, they might be quite effective, and we've seen that other places. It concerns me for less resourced institutions that wouldn't be able to necessarily defend themselves. I mean, this is an extraordinary slate of attacks against a particular institution. And as I said, Harvard is, it's an easy target, not one that's going to elicit a load of public sympathy, but it should, because of the risk to lots of other institutions that stand in the same stead. So, for example, the tax-exempt status. If you can revoke Harvard's tax-exempt status, which was granted to them for the purpose of education, then you could do that to a smaller private institution for not bending to the will or to the request of an administration. There would be no difference, right? So every private institution in the country holds a tax-exempt status just like Harvard does, and if we can take theirs, then that extends to those who are far less well-resourced and less able to withstand those kinds of attacks.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Jodie Ferise, and we'll talk about the concerns of other educational institutions. I'm June Grasso, and you're listening to Bloomberg. The future of nearly 7,000 international students at Harvard University hangs in the balance this week, with a hearing set for Thursday to determine whether a temporary block should be extended. Last week, Judge Allison Burroughs temporarily blocked Trump's move to bar Harvard University from enrolling foreign students.
Part of the problem with Harvard is that there are about 31%, almost 31% of foreigners coming to Harvard. We have Americans that want to go there and to other places.
The administration claims that Harvard failed to provide sufficient information about misconduct by foreign students and is pushing for changes to the university's governance, admissions, and faculty hiring, as well as its handling of anti-Semitism on campus. I've been talking with Jodie Ferise, a partner in the higher education practice at Church Church Hittle Antrim. So, Jodie, have you gotten calls from any of your education clients with concerns based on what's happened to Harvard?
I do. I just got a call from a client last Friday who had watched with concern as Harvard's SEVIS program was revoked, their ability to enroll international students. And I have a client that has a similar sort of ratio. Harvard has about 27% international students. And I represent an institution that has a very significant number of international students. And, and they reached out just last week, and that's one example. And, their concern was, what can we do kind of proactively? And my advice to them was, stay out of the crosshairs, honestly. You are not resourced as Harvard is. You don't have that kind of a financial depth to be able to withstand it. And you don't want to tell your clients to fade into the background. I'm not an attorney who normally would urge a client, to fade into the background. But in this instance, the best thing that we can advise clients to do, I think, is to say, watch your processes, watch what's on your website, keep yourself out of focus, out of the gaze of the administration, because most of the institutions that I represent could not withstand that kind of a challenge, that mounting pressure of a variety of attacks coming at them. So yes, I have clients who had international students whose student status was revoked. And that's the crazy part of this is it's an ongoing battle where these things go into effect and then judicial resources are exercised, and then we have an injunction reversing it, and it gets stayed, or and what happens is that in the meantime, there are things that happen. So I had clients who had international students whose status got revoked, and before the injunctions even came, stopping that and reversing it, before the administration reversed course on that, several of these students had already left the United States in April, when their semester was done in May. And it's such a shame, right? It's really affecting institutions across the country who are watching the fight that Harvard's engaged in.
So do you think there would be more sympathy from the public if the attack wasn't on elite institutions of higher learning?
Yeah, I think, and I've kind of said this already, but, I think that while Harvard might not engender a lot of sympathy across the United States or be a relatable institution, in communities across this country, there are colleges that are fulfilling these same purposes, right? Educating, becoming economic anchors of the communities. And they are impacted by these things, very much impacted by these things. I saw this morning, one of the latest things is, if they're going to take away the funding, they're going to redirect it to trade schools, and that's fine. But trade schools are fine. But what we need to recognize is that this is a yes and, right? Private higher education is important. Public higher education is important. Trade schools are important, but we shouldn't be held hostage to an administration that wants institutions to bend to their will, or else, right? If these actions are appropriate, then they would be appropriate not because you want to hold an institution hostage or force it to bend to your will. It shouldn't be tied like that. And so what I just always want to end with whenever I'm doing an interview is just an urging of folks to remember that as goes Harvard, or as goes elite Ivy League or Ivy Plus institutions, so goes 3,900 other colleges and universities across the United States who are and will continue to be impacted by the very same actions that are happening in the upper echelons of higher education. So it's far more important, I think, than maybe the average American citizen realizes, because the implications are really staggering for what this could mean. The other thing that I would say is about the international students, I want folks to realize that the world is watching. The world is watching. And while the administration may have recently indicated that they're not sure we really are receiving the best and brightest from the world, we are, and we have been. During the first Trump administration, we saw a marked downturn in international students coming here. Many of them redirected to Canada or to Australia. And I personally had students back then whose parents and grandparents urged them not to come back to the United States. So I worry that on the international student front, we will feel the effects of these decisions for generations, no matter how that all turns out now. We've already sent a message, right, to the world that we're not sure we're real interested in having international students here, and we don't recognize the contributions that they've made and continue to make, not just to our economy, but really to science, to our industries of all kinds across this country. And I worry very much about the message that we've sent to the rest of the world there.
Have any of these investigations so far come up with hard proof in numbers, perhaps? I know the EEOC launched an investigation into Harvard's hiring and whether it unlawfully hires faculty based on race and sex.
In the commissioner's charge about, where they indicated that the EEOC was going to investigate because Harvard has obviously been engaged in discriminatory hiring practices. So the commissioner's charge shows all of this data, right, that Harvard had put on a public dashboard in its 2024 annual report. And Harvard, like lots of institutions, like my own clients in the past, have had, an annual report, and they show faculty demographics and development and diversity and who, got tenure and different things. And so in Harvard's 2024 annual report, they showed the demographics. And in this EEOC charge, it says, based on Harvard's 2024 annual report on faculty development and diversity, there is reason to believe these trends show an underlying pattern or practice of discrimination based on race. So what they're actually saying, right, that is the leap it makes. Here is the data, and based on that report, there is reason to believe that Harvard has engaged in a practice of discrimination. But what you're saying, if you just look at the data and then you say, without more, there's reason to believe that you've engaged in inappropriate hiring, is that you don't believe there were that many minorities who were qualified to work there. And that is discriminatory thinking, right? And so it's strange to me how that is someone considers that an appropriate basis upon which to launch an EEOC investigation, because I did my doctoral research on this very thing, and I can give you 37 other reasons why Harvard may have achieved an increase in diversity among their faculty, and I can give you lots of reasons why it's important to do so. But they've made the leap in assumption that if you increase the rate of faculty diversity, you've probably engaged in discrimination against white, straight folks, men, because otherwise you wouldn't have this data, you wouldn't have this kind of diversity. But that itself is discriminatory, and so that is just a point that I'd really like to make, is that particular EEOC investigation to me seems like it's very logic. It's based on discriminatory logic in the first place.
We'll have to follow this and see if anything comes of this EEOC investigation. Thanks so much, Jodie. That's Jodie Ferise of Church Church Hittle Antrim. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.